Okay, we have to start. Like I said, we are going to be brief. I have insurance law tomorrow. And once I'm done, you people will start writing your own. What we are going to treat today is rule of professional conduct. When we talk about rules of professional conduct, we are going to start with even the meaning, what that very law entails, because it will go a long way to help you tomorrow. And I want you to know that if you understand it this way, it's going to help you to do justice no matter whatever that will be given to you tomorrow. First, that rules is there for lawyers, is there to guide lawyers. It's just like in medical practice, they have medical practitioner act. So also in priesthood, they also have the code of conduct, Catholic code of conduct that guides their faith. So also it applies to law. So that rules of professional conduct is just simply RPC. It's just simply the rules that governs lawyers. Then we are not going to follow them seriatim because sometimes laws are not made in a categorical form. So we are going to start with Rule 24. Rule 24 is basically talking about a lawyer ability to accept a brief that comes before him. We all know brief, right? Brief simply means ability of a lawyer to entertain any matter they bring before him, before the court. So as a lawyer, that Rule 24 is saying that as a lawyer, you are bound to accept all brief. And even before I proceed, the name cab rank or cab is gotten from this regular cab we used to enter. Do you understand? If you are going to park to enter a cab now, would the cab ask you where are you from? It will not ask where are you from. The only thing you ask is, this one is going to Obe, this one is going to Umeze, right? So that cab is gotten from that thing, cab rank crew. The meaning that as a cab driver, whatever that comes to you are bound to take the person, provided the person can do what? Pay you. And provided the person is going where you are heading to, isn't it? So if you are going to Umeze now, and because I'm short, and probably I'm going with Peter is very tall. So the driver will not say, see, you are short, don't enter my car. Neither will he tell Peter, you are too long, don't enter my car. So he's going to take all of us in. That is where they got that idea of what? Cab rank crew. Meaning that as a lawyer, whatever comes to you, you are bound to take it. There is no discrimination and there is no basis for saying that I'm not going to accept this brief. After all, you kill this person. I'm also going to come into that angle. Now, when you are talking about cab rank crew, that is where you are. Remember what I said that we are going to do today is more of practical with cases and authority. Isn't not? It's good, right? So I believe you people can actually read it on your own, but at some point we will even be reading it, so we'll be flowing. So when you talk about that cab rank crew now, the provision or what sponsored that thing is Section 36 of the 1999 Constitution. Section 36 is basically talking about what? Right to fair hearing. And under Section 36 of 5, every person is presumed innocent until when proven what? Guilty. That is the principle. So this principle of cab rank crew say that even if I'm watching somebody dying here as a result of the action of this person, if this person comes to me as a lawyer, I'm bound to do what? Listing and give him what? Audience. Remember what one of the rules of natural justice says what? Audi Otarian patem, right? Nemo what? Exactly. So the principles of cab rank rule now is gotten from the constitutional basis of Section 36 of the Constitution. You see that in 24, every law student must know it because it's what makes you a lawyer. That's why it is on this basis they normally say that we lawyers are what? Liars. Because this person will kill and they will come to us, we will still entertain them. So this Section 24, Rule 24, is what justify our action of representing both the criminal and not criminal. Are you people getting my point? So Rule 24 is saying that irrespective of whatever you think that person is bound to have access to court and to have access to fair hearing. For example, if there is a kind of analogy that suggests that that person is too churchous or too holy, that he doesn't take brief, and you are meant to advise that person, whether you are churchous or whatever you are doing, the principles of rule of law is that you are bound to represent anybody that comes before you. Then we're also going to examine some exceptions because in every rule in law, there is exceptions. So that is just the principle. Now, when you are talking about that Rule 24, there is also some certain cases we are going to mention. I've talked about Section 36 as the constitutional basis. Then you can also add Section 36 of 5, which talks about what? Presumption of what? Innocent. Meaning that if somebody is being killed here, we will still term that person innocent until the court says otherwise. Then the next thing also you can add is the principles of, because I said Latin maxim can serve as authority. Are you getting me? So you can actually mention audi uterem partem, meaning that you have to hear from both sides. We shall also come to the second rule as we progress. Now, there is one case known as the case of Udo Ofia and the state. Case of Udo Ofia and the state. It is also one of the cases that can be applied here. In that case, there was a person that murdered his own mother. The person killed his own mother. And you know, back then, this thing happened around 1980, 1970. Of course, you know that somebody killing your own mother is it's not, apart from being a crime, it's abomination, right? Then you can relate back to that olden days. Even now, things have spoiled. Everybody can do anyhow, we still condone it. But that time, killing your own mother was seen as abomination. Then in that case, that person murdered his own mother. Then, you know, due to the grievous and how bad that offense is looking, many people were not ready to represent him. So the question before the court, during the first trial court, there was no counsel to represent the person, and he was convicted for murder. That is Udofia. He was convicted for murder. Then on the appellant court, the court then still affirmed the judgment of the higher court. Then when the matter get to the Supreme Court, Oputa JSC, one of the judges there that read the lead judgment, says that no matter how grievous someone's offense is, that person still have right to enjoy right to fair hearing under section 36 of the 1999 Court. This thing I'm saying is the authority you can use. Like I said, what we are going to do now is to marry whatever we have read with cases, and then you see how it applies. So he said that no matter how grievous this offense is, the person is entitled to what? Fair hearing. Then one of the issues canvassed in that case was that at some point, after even the counsel that represented the person at the trial court was not even ready to represent. He will come today and he will not come another thing. He keep on adjourning the matter, and at some point, even during cross-examination, when you get to criminal law, you see how cross-examination works. So he could not even pay attention to that brief, to attend to it the way he should, and the guy was convicted. Then the guy went to the appellant court. Appellant court, on the other hand, that is court of appeal. Instead of looking into it, they still make the same mistake. They made the same mistake, and then the matter has to get to the Supreme Court. Then when the matter get to the Supreme Court, that was when the Oputa JS then started bashing at that counsel, saying that no matter what, first of all, even that very matter, the person that represented was just a person from NYC, just like you are called to bar now. You know, I think after law school, you go to NYC, right? So you see that that person has not even practiced. Then under section 46 of the 1999 Constitution, if you are an accused and you don't have the right to access a lawyer, the government is bound to provide you a lawyer, provided it's a capital offense. Capital offense are those offenses that once you commit, you are liable to being sentenced to death. Something like murder is a capital offense. So in all capital offenses, if you are being charged in the court for murder, they are going to try you, and the Constitution provides that the government should provide you with a lawyer, whether you have money or not. Then, what they provided this very man was a person that just finished service. No wisdom, nothing to hope on. The person was just being negligent with everything, and they end up convicting him. Then when the matter gets to the appeal, from the appeal, they also affirmed the judgment of the higher court. Then when it gets to the Supreme Court did what? Overruled it and set the accused free. So are we people seeing how this thing connects? So if you are then analyzing section rule 24 now, we are going to simply make sure you let the lecturer know that this rule says that everybody is entitled to, number one, right to fair hearing. Number two, not only representation, but effective representation. So I think, should we read that rule? This thing you say is very important. Like I said, you mustn't cram to pass this thing. I didn't cram, and I don't think I am regretting my result either. So you mustn't cram to pass it. At this point, don't think like you have to say quote exact thing section 24 says. Of course, there are some you have to quote if you can, but if you try to cram it at this point, it's going to be overwhelming, and you may have miscarriage of justice in the examination hall. So it's better now. What you are going to do is that if you come to rule 24, first of all, what is the main principle in rule 24? You note it down. Then, secondly, another thing you're going to pay attention to is what? Exception. Exception is very important because if you didn't get the exception right, it's going to mar whatever you have done in your paper. So if you can actually capture the first heading and then go to exception, you can actually say if you are doing it, it has paragraphs A, B, then you can actually just capture section 24 and use it to, I don't know, to encompass whatever thing that is there. Then you can actually then group exception in different way. Are you getting my point? So if you come to Rule 24, you can encapsulate whatever that is there to simply mean that as a lawyer, you are entitled to accept all brief. Provided it is in the court, you do what? You practice. That is very important. I think let us even examine those elements because it's very important. It's not just enough for you to say that as a lawyer, you are bound to take all brief that come to you. And like I said, when I mean the brief there implies all cases that come to you. So if it is not in the court you practice, you can actually not take the brief. Court you practice doesn't mean Enugu State High Court. I practice at Otubu and High Court. No, no. It means whether you are specialized in criminal litigation or you are specialized in business law or you are specialized in what? Civil matters. That is what that thing implies, not your regular court. You people get what I mean? So it's not just your regular court. Maybe you say I am not specialized in state high court. There is a way those courts work. It's not you that determine the court. It's the jurisdiction that determines the court, which you're going to do in second J. You then know the right court when action happens. It's not all court. There's something that will happen here. You will not go to state high court. You go to federal high court. So also to Supreme Court. So that's how that one is, by the way. Now, one of the elements in that Rule 24 is that it must be in the court the lawyer professes to practice, which I have explained, meaning that it must be within your own sphere of practice, whether civil or criminal. You can't be a jack of all trades. So it's not possible. Then, at this point, we are going to examine some exceptions. So one of the exceptions to that thing is that if a lawyer has interest in the subject matter, a lawyer is bound not to take the brief. If a lawyer has interest in the subject matter in the litigation, a lawyer can actually not do what? Take the brief. A lawyer can actually say, I'm not representing. Having interest means is that, let me say now, what will I use as an example? Say my chamber now is King's Advocate Chamber. Then I have issue with somebody. Of course, I'm a lawyer. Then I have issue with somebody, or somebody used my name. Somebody is passing off my name, what we call in law of thought as passing off. Somebody is using my name to create another thing and to do another thing. That thing now is trying to take away what belongs to me, which I'm the legal owner. In this case now, I cannot actually go and represent the other party. Neither can I actually represent myself. Because nemo juris in consensus applies here, isn't it? You can't be a judge in your own case. Neither can I also go and represent other client, or one of those in my chamber will go and represent other client. It's not possible now. Because whatever we'll be doing, it will actually conflict with what we are doing legally. Are you getting my point? So if your interest is at stake in that subject matter means what is being litigated upon or what is in issue. That thing is subject matter. So in this case now, there is no way I will go and represent that party when ordinarily my own interest is at stake. So in this case, I'm bound not to take it. Then another thing, if the party have not furnished remuneration, that is money. Of course, what is life without money? If the client have not given you money, or if the clients have not paid the adequate remuneration needed, you can actually not take the brief. But remember, remuneration is not a condition precedent to you representing a client. I will explain what I mean by condition precedent. Remuneration is not actually what is needed or what you can count on and say that this is the basis for me to represent a client. That is what the rule says. But this also could be one of the exceptions. If your client is not worthy or is not ready to give you the material welfare that is necessary for that case, you can actually not take it up. Then I want somebody to open that rule 24. You will have it in your phone, but somebody that can read should just read one. That first this thing. Thank you. Why I say she should read it is because of this thing I say. What? There is one thing you mentioned. Fee is offered. So that one now is a very big exception. Then number two says what? There is something we read, except in exceptional what? Circumstances. So those exceptional circumstances imply some certain things. Just read down a little bit. Mhm. So it is the responsibility of a lawyer. That one will still come to that. But then these special circumstances can be found in this rule RPC. These special circumstances can also be found in other laws. Like I said, I pointed out the rule of natural justice, which is that no man shall be a judge in his own case. Obviously, this thing is not provided in RPC, but the Constitution have already encapsulated it that you cannot represent yourself or be a judge. Okay, Rule 17, right? So you have seen now that all these things, some exceptions can be found in this rule, and some exceptions can be found in any other law. That is what that rule says. So exception can be found in various rules and also in some other laws. Now, there is another rule that is very important. I think there is a place that talks about exception that in that rule 24. Read down a little bit. So, as a lawyer now, this one have suggested that you are bound to take brief wherever you see brief. Then, for the fact that you are bound to take brief wherever you see brief does not also mean that you are going to do the one that will be prejudicial to the justice. Then another case also there is case of Josiah and the state. I mentioned Udofe and the state, right? Then talk about section 36, sub 6 of the Constitution. So there is another case there. Yes, section 36 sub 5. Another case there now is case of Josiah and state. Josiah and state still have similar ingredients with that of Udofe and state. In that case again, the rule of the law as established, the same justice again, Oputa JSC, says that if a party or if an accused is being charged with capital offense, the accused is bound to have a legal representative. And in the absence of having a legal representative, that will vitiate whatever the courts have done over his matter. This thing simply implies that if you are charging somebody for criminal offense that is heavy as capital punishment, I have defined what capital offense means and the punishment death, which is death. So if you are charging somebody with such a heinous crime, you are going to provide that person with a lawyer, whether the person can afford one or not. You are bound to provide that person with a lawyer. So that is what this thing is trying to tell you now. Here becomes that basis that justify the need of a lawyer taking every brief you see. So if there comes a problem question that try to, merge this thing with religion and merge it with so many other things, just know it that as a lawyer, as far as this rule is applied, you don't have much wide discretion to choose the one to take and the one not to take. That is what this principle is saying. Then, when you go further to Rule 14, Rule 14 talk about lawyers-client relationship, right? Rule 14 now, somebody should read that Rule 14, just that first page. A lawyer should devote his attention, energy, and everything he or she has to the best interest of his client, subject to any rule of law. That is very important. Mark that word, subject to any rule of law. So, in as much as you are representing your client, in as much as you are doing everything possible for your client, you must make sure you don't go contrary to what the rule says. Are you people getting the point? Yes. So that is what that principle is trying to tell you. Because this principle now is trying to say that you have taken the brief, now it is your turn to represent, and not only represent, but to represent effectively. That is what this principle is saying. So if you go further in the case of Awolowo and Takuma, it was also one of the issue in that case. In that case, what happened in that case is that a lawyer was very negligent in his act of representing the client. Issue was before the court. Then even the lawyer, this thing has a lot of things to do with so many rules. It has a lot of things to do with so many. It doesn't just apply to one rule. So as we analyze it, you are going to see how it features in various rules. So in this very case now, a client, you are representing a client. Then instead of being active, I don't know if you have been in court and see the level of adjournment these people used to have in the court. You can go, like you will not even see. That's why I even stopped going to court, because You will stay there and you not even see any matter being. They will just call, my lord, is 27th free. They will just be 27th August. This thing we are talking, maybe in May, you are hearing 27th August. Just like Nnamdi Kanu, they have adjourned the case till October. You can imagine. It's a case that started almost since 2015. If you go to court, they may, Lord, can we check August 31st? They go to court, they do all sorts of things, which can even be detrimental to that of both the defendant and also to the rest of plaintiff. So that's what this rule is saying, Rule 14. It's saying that you must devote your attention. You must do everything necessary to ensure that you don't jeopardize the interests of your clients. That is what this rule is saying. Of course, you know Nigeria, the rule can be there, but we'll do our things. So, because obviously, those that made this rule actually know what this rule is all about. So that's why they are very conscious of it while making it. But we are still disobeying all of them. So this rule, now when you are talking about this one, first of all, what they are going to test you now, they can actually present various issues that may relate to negligent act. When you come to tort, you will see how this negligent act applies. Just unnecessary lack of attention to your client's matters. They can actually present it in such a way whereby it will portray the lawyer as being nonchalant, not ready to do the necessary things, not ready to file the necessary things. This one has more of technical origin. So in this case now, you are bound to entertain your client brief with all seriousness. Inform him the necessary things that is needed. Also here now, you are bound to make sure that you give your client the necessary information that is concerned about that matter. In as much as you are doing it, make sure you take care of all things. Make sure that he or she is aware of whatever that is going on. Now, if you can actually, why writing? Because of course, you need this thing for your normal knowledge, and you also need to pass the exam. So if you are passing the exam now, just for the sake of tomorrow, you can actually, if possible, you cram that section. If you can then quote it, you try to analyze it. If the question comes in essay, you can actually quote it and then try to analyze it. But assuming it comes with problem question, you can actually then bring that section, your understanding about it, and say that maybe Udoka, based on this act and this act, he has gone contrary to the rule 14 of RPC, which says that a lawyer shall devote everything he or she has to ensure that he gives his or her client the best. So are you getting what I'm saying? So it's all about just juxtaposing that, your understanding about that very part of the case, to relate it with that rule. Are you getting it? Then I want you to read rule 14 sub 2. Thank you. You see that sub C is very important. There's some scenario or there are some problem questions they can paint, and you know, as a lawyer, you don't have a good case. You know, all these things has a way it connects. Remember rule 24 said that you are bound to take brief, right? Well, there are some certain matter you will look at, and you know that you don't have a good case here. You don't just say, okay, I'm a lawyer now, I will accept it. It's not, let's go to court and you know what people are saying. Let's, after all, we can actually exchange money. Leave all these things that are saying exchange money. If you know electoral matter, forget it. It's only electoral matter that, you know, they carry money for Ghana must go. But if it's just ordinary land issue, the judge will not even look at your face. So if you have, there are some cases you read from 200 level, but you see how the court will bash a lawyer, like how the court will embarrass you. In fact, you can be filed for contempt of court for filing frivolous charges. That's what we call it. A case that you know that doesn't have merit, you then still insist on taking it to the court simply because you want your money, your pocket, to fill your pocket. Because every appearance fee comes with 100K or something now. So you see how that is what this thing is saying. That if you have examined, assuming now the problem question comes, then you have seen. That is where, you know, the problem question they will tell you, have you people say something, advise the parties? That is where this ingredient comes in. This ingredient you have seen, that is where it comes in. If you have seen that that client, let me just put it that way. Yeah, when you want a good case, just tell him, my friend, relax, don't go to court. Advise him in that your paper. It depends on how the question will come. If there are some certain questions that have raised the issue already, there are some certain questions that will be open-ended and say, examine the issues. If you say examine the issues, then, or examine the issues and advise the necessary party. In this case now, you can raise issue. After analyzing that issue, you advise. You say, based on this issue above, or based on whatever I've said here, I proceed to advise my client that he should not go to court, that you don't have a good case in this matter. Although Rule 24 said that I'm about to accept brief. But it is also mandated of me by virtue of Rule 14 that I should advise my client on the right of course of action to take. Are you following me? So all these things, that's why I say we should be following it, not just the way it's stated. Rule 24 will lead you to Rule 14 because they are connected. You are bound to take brief, yes, accepted, but then you don't take everything and go to the court because at some point, the court will bash you. There are some cases the court will embarrass the lawyer and tell him that you have come here to waste the times of the court. So that is what this thing is saying, that if you have examined your client matter, you don't just use because of your proprietary interest, what you want to gain and all those things, the benevolence that may come into the matter, or in fact, you are business. You begin to go to court without necessary this. Can you read down a little? Just know that particular first rule. That this first rule, okay, you want to ask a question? Looking for a simpler example I will use now. A simpler example that will not be too out of. I want to use thought now, but it will be too big. Let me just assume it's during election interval, and then they have made a law that drinking of alcohol is prohibited, just like it's prohibited under the penal code, that is prohibited in the southern part of the country. And to give effect to this law, we are backdating this law to take effect from 2023. Are you people getting it? So this law now has been backdated. Is backdated law valid under the Nigerian Constitution? Which section stipulate that? Thank you. 36 sub 12 say that law should not be backdated, right? Then we also have, then that is one issue. Then second issue, not only that the law was backdated, but the law that was made today provided that whoever violates that law is going to be sentenced to 21 years imprisonment. Then, because one of the heavyweight politicians in Enugu State was involved in violating that law, then they say that the person shall be sentenced to 30 years imprisonment. Is that punishment valid? Which section provides for that? Section 36 sub 8 says that nobody should be punished more than as provided when that law was made. I'm just paraphrasing that section. So in this case now, if you are saying, if you remember I'm using this as an example, right? So if this matter now come and they say, advise the Attorney General who prosecutes in criminal matters. Who prosecutes in criminal matters? You don't know who prosecutes in criminal matters. It's the state that prosecutes. So in this case now, if you're advising and they say, advise the Attorney General and also the Defense Counsel on the right or otherwise of this very action. In this case now, will you go and advise Attorney General to go and still continue with the action? Will you? Will you advise the Attorney General? You will not advise the Attorney General because of what? I hope we are together. What I'm trying to say that she's trying to see analogy whereby you can advise your client to withdraw the matter, right? So we just use a criminal matter in this case. And I'm trying to tell you that we have obviously seen that in this case, there is no justiciability or there is no ground for you to maintain an action because you already know the principles of law in this case. So there is no need of telling your client. Remember, this is more of academic. We are following into academic. We are not going to court, but we are trying to analyze this in academic perspective. So advising your client in this case, you are not going to tell, assuming you are advising they normally say advise the prosecution and also the defense counsel. So you come this side, you tell this person, based on the section 36 sub 12 of the Constitution, it is the law, any law that is made and is backdated is not and void. Then you come to the other side and also tell the person that it should not be deterred or moved. That even if the prosecution initiate this matter, section 36 sub 12 is in your favor. So there is another case I want to also point out to you people. Very important. Linwood and Andrew. After I'm done analyzing this case, then you will tell me the relevant section that falls under this case. What happened in this case is that a barrister knowingly adduced a fabricated affidavit before the court. So while doing that, a motion, if at some point I use all this language and you are confused, just let me know. So he adduced a fabricated affidavit before the court. And what is affidavit? Affidavit is simply a written statement made by someone under an oath that whatever is written there is nothing but what? Truth. So it's not just your regular affidavit way to go to court during your filing. So he fabricated this thing and adduced it before the court, in that case of Linwood and Andrew. Then a motion was raised against him to commit him for contempt of court. You people know what contempt of court is? You don't know? Contempt of court is just a court's way of sanctioning you for going contrary to either rule of justice or rule of the court. One thing about contempt of court is that it is summarily done. Like, there is no need for give you fair hearing. It can be done, imposed on you instantly. So in that very case now, they filed him for contempt of court. The motion that was raised against him was for contempt of the court. Then the lawyer then tried to blackmail the court and start telling them, you are just trying to commit me simply because I accepted my client brief. I don't know if people are getting this point. He accepted a brief. Then, in the course of it, he knowingly, very important, because under section 24 of the criminal code, he cannot convict somebody of a crime he is not intentionally aware of, or he has not intentionally committed in the exercise of his will. So any crime, that's why some madman now, they will kill you, they will go away, will not do anything, because they didn't do it with their senses. So he was then trying to blackmail the court and tell them that if you are convicting me for this, was it because I decided to take my client claim? You know, trying to blackmail them based on that rule of course, this is an English case, but it was trying to counter the court based on that rule of 24. We say that you are bound to take everything, whether it's good or bad. Then the court told the man and said, no, you cannot just blackmail us. We are not committing you for representing a client, but we are committing you for going contrary to nature of justice, which say that you ought to do everything as a lawyer to ensure that what? Justice is what? Served. And under section 117 of the criminal code, it is perjury to adduce false evidence before the court. Under section 118 of the criminal code, it is punishable by 14 years imprisonment. So he then, what he have done now amounted to a crime, although that was civil case. So looking at this case now, I will still repeat the fact. A lawyer adduced a fabricated evidence before the court. Then he was relying, when a motion for contempt of the court was raised against him, he tried to persuade the court or to cajole the court and tell them that he can't just be convicted because he represented a client. Then the court says that you knowingly adducing such evidence before us amounted to perjury, and it is a crime. Looking at this case now, which section of these rules of RPC can you link it up to? Wow, intelligent people about. So, thank you. Then can somebody like throw light on it, how it connects? I'm happy that you people mentioned that rule exactly the way it is. How this thing then connects to that rule, how you can actually justify it. Remember, you people just mentioned how many, which one said? Rule 15 sub 3, 3H, paragraph H. Rule 15 sub 3, paragraph H. That's how paragraph H and G, right? Then, which other rule again? Rule what? Which other one again? Rule 30. In fact, I want us, you mentioned rule 15, right? Somebody should open that rule 15. Rule 15 what? Sub 3 what? Rule 3. Oh yeah, somebody should mention that rule 3, 15, paragraph H. Then another person, who again? Somebody mentioned. No, I'm not interested in this paragraph. Rule 32. I may open your own. I want us to read it. There is another section. 30. There is another one which we have discussed and none of you have mentioned. No. So can somebody do that rule 15 sub 2 paragraph A? Another person, you still read it. I want us to get this rule together. Which other rule again? You mentioned 32, right? Somebody should. Your name. What is your name? Your name. Chisom. So Chisom, you will read that one when they will read this one they are finding. Now this section 32. Somebody should read. Read rule 32 sub 2. Then somebody should read. You people didn't mention this one. Rule 14 sub 1. Rule 14 sub 1 and rule 15 sub 2. Why I'm telling you this now is that you link this case up to it. I don't think I've said this. It's not just enough for you to cite this section. No. Like, it's not just enough for you to go and cite only section. Remember, your lecturer know that section. He's not just calling you there to go and post section for him. You want to test your own knowledge on your understanding of how it can apply to real case. because you're already a lawyer. You can't see this rule again in your life. Like in the course of your academic, you are done with it in year one. It is presumed, which is reportable assumption anyway, that you know whatever that is there once you are done with year one. So the only time you will see it is when you consult it as a lawyer, probably to make a case. So that's why they will critically test you on it. So that's why we are linking it up to this case, so that if you see something that relates to this one case can actually have everything to do with these rules. His ability to understand it. Now, if you go to this Linwood and Andrew, you then know that, first of all, as a lawyer, based on Rule 15, you are bound to represent, but it's still within the what? Bounds of the law. Assuming your client then try to push you away or try to push you more than you can go, then contradicting your first responsibility, which is duty to the court and duty to justice, you are bound to what? Reject it. Then if you continue, you are doing it under your own what? Peril. I hope people getting how this thing connects. So Rule 24 give you right. Rule 15 is then trying to tell you how you can exercise that right. And this case of Linwood and Andrew become a beacon for us when we are talking about that very section. Then I talk about Rule 14. Just read that 14, first paragraph. Sub 1. There's something like Thank you. Subject to any rule of law, and also in a manner consistent with your client's interest. So if you are not going against the law, guy, whatever you're going to do, make sure you win that case. That's what this thing is saying. If you're not going against the law, just do it. But if it's going contrary to the rule of law, you cannot rely. Remember, are you people getting what the counsel said? He said that, are you trying to convict me because I am representing a client? Then the court say you can't blackmail me. I'm trying to tell you I'm convicting you because you knowingly adduce evidence which amount to perjury. Are you people getting the point? So this is how this thing connects. And behind every rule lies what? Exception. Yeah. Exactly. It was even that rule. I wanted you people to mention it. That rule feature here heavily. So if you can see now, we have Rule 15. Then to save it, because I am seeing something here. I'm seeing that you people are battling with the confusion of paragraphs. But let me just advise you. If you run mad there, I advise you leave that paragraph. I know why I'm saying this, because there's a way you do this thing. You go to hall, guy. You will be missing it up. So if you know it will, I'm coming. If you know it will going to conflict with your interest in that hall, kindly know that Rule 15 is talking about representing a client within the what? Bounds of the law. He will not shoot you to death because you didn't mention the paragraph. Are you getting me? But if you can do it, fine and good. If you can do it, fine and good. But if you be wasting your time and thinking paragraph what, is it H? Is it A? Next thing, submit your paper. And let me share what thing I do now. After my 200 level was like my worst class. After my 200 level, I saw a note that my script will not be vacant. In 200 level, we are dealing with people know Professor Buna. He will tell you that after your exam, they should use 2 hands and carry your script because of whatever you have written there. But you end up in second year, I was answering only one jurisdiction. They are saying 30 minutes remaining when I'm in one question. Like the thing. At the end, God forbid, that man may not even have the time to mark whatever you have written. And they end up giving you, the mark there is 17. You mark at 12. You are too intelligent, you 2 side case, they will give you 12. 12 minus that 17, the other mark is going, right? But assuming somebody attempted all question and got 10, 8, 8, 8. If they calculate it, which one will be bigger? That person that. So are you seeing are you getting the point? So instead of trying to cram paragraph and confuse yourself and keep wasting time, just summarize it. Know the exception. If you must cram paragraph, it must be with respect to what? Exception. Because that differentiates that very section. So let's take note of that. What? Exactly. Exception. During my time, actually, I can recall most of those sections verbatim. Because, yes, I crammed it. If you understand it, you don't necessarily need to cram it. But you know, there's one thing you do to make A. There is a way you write to make A, actually. I used to write with red pen. Like, I will come and say, If I cite a particular rule, I will use red pen in the center of my book to write it. Then I will use blue pen to be analyzing it. You know, that thing will actually make you appear intelligent. So it all boils down to you. If you want to appeal the lecturer and get his attention, if you can cite the rule verbatim, fine. And one thing why sometimes I used to cite it is because it helped me. Because if I have cited it like that verbatim, it will give me opportunity to elaborate. But assuming will you explain yourself? That means you can't explain yourself. You will be talking too much. That's what they say you to explain. Like you will lose your steez. If you just you'll be ranting. But assuming you quote it, you are liberty to what? Explain. That is the disadvantage. But you can't explain what you have already quoted yourself, quoting yourself. Okay, we are still going to come to that. Room 19 is very important one. So I believe now I'm coming to that. So we have done Linwood and that. I want us to mention the case you have pointed out. No, we start with first one. Mm-hmm. I'm going to come to your question. Just wait. Because what we have come here to discuss is cases and how it applies. There is another case known as the case actually has a lot of things to do with many of these things. But it basically applies to, representing a client, doing everything. It applies to Rule 14 more. Representing a client with all seriousness. That is lawyers-client relationship. Imadeboho. That case is Bini case. So what happened in this case is that, pay attention, because after still, I'll still ask you a question here. What happened in that case is that a person was convicted of a murder by the trial court. Sorry, I said convicted. The matter was still before the court. He was charged for murder. Then the police, in order to prove their matter, and again, do you people know what the Queen represents here? I said, what does it represent? Thank you. The Queen represented prior to 1960. We all did government, right? Queen England was our president and head of state. So that's why if you see criminal law, you'll be seeing it more. Queen. We are still under the colonial master then. Queen was representing the state. Then if you see R was standing for republic. There was also a time we were a republic between the era of 1960 and 1963. So what I'm trying to say here is this is a criminal matter. State represented by Queen. Now, having said that, we'll move to that part of that case. So that person was charged for murder. Then the police adduced evidence showing that he made a confessional statement to the police. And that confessional statement, the accused himself denied ever saying anything at all. He didn't say, he said that he have never made any statement. And in fact, the irony of the thing is that the statement was made in English when the accused cannot speak English. So you see the discrepancies there. Then he was saying that I have not made this statement, and this statement was in English, which obviously I can't speak English. Where did I say that one? Then in the course of the ruling, then the lawyer to the accused, erroneously, I don't know how it arrived at that, and then started telling the court, this is not what my client told me. In fact, he told himself that he was not around, that he went to tap wine on that very day. That thing happened. He just started narrating whatever the client had told him before his chamber. He started telling that he was, that what happened, that the clients told him that he went to tap wine that very day. So that thing, that is the way he insinuated it, or that is the way he said it, that tantamount to going contrary to what the accused admitted. Remember, the accused admitted not saying anything. And in fact, alienated himself from that very crime. Then this lawyer went extra mile to ruin the matter. So looking at this now, which rule do you have in mind in this case? Rule 19, right? Thank you. So that statement, the lawyer said, let me just quote him. My original instruction was that the accused went to tap and wine on that very day. So what he's trying to say here, if you read that full case, is that he was trying to say that even the accused is lying to me, sir. That he didn't even tell me what happened. Sir, I'm even confused here. Then the court, in order to address that matter, then begin to delve into the realm of what? Rule 19. And what does Rule 19 say? So that Rule 19 says that whatever you and your client have discussed is still privilege, provided it's with what? Within the what? Cost of employment. You people understand what cost of employment means, right? This thing simply, now let us just consider the element of Rule 19. one of the elements there. When I mean elements, I mean if you come to rule 19, what are the things that make, are you getting me? What are the things that made up that rule 19? So that you can actually understand that rule 19 better. So rule 19 in this case now is saying that whatever your clients have told you or have discussed with you are privileged, provided it's within the course of employment. Course of employment means that it must be within that time you people are discussing on the subject matter or litigation matter. It can be maybe you are discussing another thing. If the matter have gone contrary to your anything that pertains to litigation, which is the matter the client has come before you, you are free to do what? To disclose. Are you getting the point? There is a question they will ask you this thing. You even see a scenario whereby what they may have discussed is not something that related with course of employment, and you may just jump and say you cannot discuss. Are you getting me? So that's how they paint this question. If the lecturer is active and want to do justice to this, that's the way we state it. You will jump and conclude that you have actually disclosed when you have not disclosed anything. The rule say the caveat there is that it must be within the what? Course of employment. Any other thing that is said, whether advice or whatever, that is not within that lawyer-client relationship cannot fall under this. Then, secondly, for it to amount to such a thing, there must be, for you to disclose, there must be what? Consent. So first thing is that, what did I say is the first element? Course of employment. Then the second one I say about consent. So assuming now, you can actually disclose whatever the client have told you or whatever the client have discussed with you without necessarily, being breaching the law, provided the person have given you what? Consent to do so. Now we are going to somebody should rule that rule 19, just that first heading. So we can also point out some exception to the and what? Okay. So under this rule now, we are going to consider the exceptions. So all of us are at the same pace with this rule 19, what it's talking about. Because you see this rule 19, rule 15, rule 24, 14, they are the major ones. You don't joke with it. Rule 15, 24, then it depends on the lecturer. We have seen now that whatever that is made, provided is within the course of employment, there can be no what? Disclosure. Then the exception to it is that if the client has consented, you can do what? You can disclose. Then another exception is that if you are mandated to disclose by the court of law, you can do what? Disclose. I hope people noting this thing. So you can actually disclose if the client has consented, going by the express provision of that rule 19. That is rule 19 sub 3b. You can actually disclose. Then if you go further, you can also disclose if the client have consented, number one. Then two, if the court mandates you to do so or the law imposes an obligation for you to disclose, you cannot say because your client have not, tell you to disclose, you will not disclose. Then another thing you have to know is that if your disclosure is in furtherance to justice, you cannot be held liable. What am I saying? If that disclosure is made in good faith, bona fide, you are making it disclosure in order to prevent crime, you are free to do what? Do so. So if they paint a scenario now whereby there is a kind of a client trying to fabricate evidence, trying to do this one and trying to do that, then the lawyer went to the court and just a scenario like that and disclosed, you can then apply this wisdom that you check the facts first. This disclosure, was it made in good faith, bona fide, or was it made in bad faith, mala fide? If it is in good faith to protect the law, the lawyer is exempted from any legal liability. If it is just ordinary negligence disclosure, the lawyer can be what? Held what? Liable. So are we following? So that is just the exception to this rule. I think there are many exceptions to that rule. Then another thing is, when it comes to this rule 19, there is another important section. Section 191, 192 of evidence and also 193. So that very section 192 specifically made it a mandatory that whatever you and your client is doing in the course of employment, it just that section 192 of evidence act is just almost similar to this rule 11 of rule 19 of RPC. So they are just the same thing. But but you can use that to support your claim when you come to that one. Then this case of which case did we point? That case of Queen and Imadebeho can actually this is one of the cases you will cram and cram the spelling. So you just cram it and cram the spelling. And then I believe you people can actually relate to what happened. Like a lawyer acting negligently to the extent of saying everything the client told him. So you can actually say now that as it was said in this case, that even a lawyer who negligently disclosed what the client told him in the court amounts to a breach of rule of professional conduct. So this is how this thing all intermingle. And also within this Queen and Mmadeho also applies to Rule 14. It also applies to Rule 14 because of the how the lawyer portrayed that matter, how he was very negligent. Remember that Rule 14 is lawyer-client relationship and how a lawyer should devote everything he has to the welfare of the client, but he failed to do so. Another thing you are going to look at while talking about this Rule 14 is Section 6, I think 6 sub 3 of Money Laundering Act. Have you ever heard of it? Section 6, Section 6 of Money Laundering Act. People have not heard of it. That very section is trying to say that is one of the statutory provisions that went contrary to this rule. Remember we talked about Evidence Act, but then this Money Laundering Act is saying that if the matter is something that has to do with a client money laundering issue, irrespective of whether privilege or not, the lawyer should make it known to the security agencies and he will not be liable. So, you know, statute law is a very supreme law that whatever he says becomes, that is not justiciable. You can't debate on it. So sometimes they can make a law. Most of these things are just common law origin. But when a statute have expressly said that you can disclose, you can disclose. And one of it, the ground, is that Money Laundering Act. So you can actually rely on it, or if the lecturer paint a question that borders or serves on money laundering issues, just know that a lawyer who disclose anything in pursuant to Money Laundering Act or any related crime in it will not be held liable. So I think this is just the major element in that Rule 19. So is there any other challenging thing in that Rule 19? Thank you. So when you talk about this Rule 19, exception is very necessary. Exception is very necessary. Can you read down that section, these exceptions? Because it's necessary. The intention of his crime to do what? To commit a crime. So if a problem question comes and it has an element of committing a crime by the client, a lawyer can do what? Disclose. If a problem question comes and it has an element of a lawyer trying to get his money from his client and thereby making a disclosure, he is not what? Liable. If another matter suffers on money laundering issue and the lawyer made it in good faith, he is not what? Liable. And I think the exact section that governs the Money Laundering Act is Section 6 sub 9. You don't have to go and look for Money Laundering Act. The knowledge is enough. So just know it that these are the exceptions when you talk about that very Then I want us to Rule 15 because that is a very important section. Cannot joke with. Rule 15. So this Rule 15 now is trying to tell you, like we pointed out in most of these cases, just know this Rule 15 is the heart of this RPC. Know it. So in as much as you have the right to represent your client, know to what extent you can go. And assuming it comes with an essay question, just in this Rule 15, you're actually free to make your point. You're actually free to know, as a potential lawyer now, at least you know, apart from this RPC, you know some certain conduct that are gross, right? You know some certain thing that doesn't fit into this lawyer stuff. So you can actually just cite the rules and then try to use your understanding to expatiate further on it. Then if it comes with problem question, your ability to marry that problem question, marry the fact with the law is what will fetch you your mark. So you have to know then to what extent have this thing he did have it gone or traversed, or is it still within the bounds of the law? That is what this Rule 15 is talking about. So assuming he have acted contrary to the law, and remember the rule still expressly stated that even if it becomes a kind of a force or a push that a lawyer must engage, he should do what? Terminate. But you know Nigeria will not agree for anybody. So in fact, it is even the lawyer will tell you have a good case now, just relax. No be me again, just calm down. Now today I started handling this matter. So you will be the person to be pushing. At the end, then the client will go contrary to the law. And God forbid that if the client if the lawyer commit the crime, you are still going in for it. So this case we are going to analyze now is going to tell you about this thing. So there is the case of Goodenough and Spencer. Goodenough and Spencer. Yes, Goodenough, one word. Goodenough and Spencer. In that case of Goodenough and Spencer, what happened there is that a lawyer, you know, was pushed by his clients to go extra mile. Then in the course of doing it, he committed a crime and he decided to rely on legal practitioner immunity. Of course, you know that a legal practitioner, that immunity upon lawyers. In fact, there is many immunity upon the judge. A judge, have you heard that a judge is tried? A judge can't be tried except if he's a magistrate court judge. Because under the, I don't want to go far now. Under the under constitutional law doctrine, there are some certain matters, or when you be doing jurisdiction, very few people are already in year two. People are already in year two, just within the space of days now. Senior counsel, junior one, and now appointed senior counsel. So within that jurisdiction, there is a way a magistrate court where a magistrate court falls under non-court of record. So non-court of record doesn't have much immunity than the court of records, which start from high court, then down to Supreme Court or up to Supreme Court. So that if no matter whatever a judge do, provided he's sitting on that seat as a judge, it's very difficult. You cannot prosecute him, especially if it is a high court judge, or if it is a magistrate court is liable for any of his action that went contrary to the rule of law. In criminal law, you still understand more. So I was driving home a point in this case. So legal practitioner has immunity. That's why the import of that immunity is that, you know, as a lawyer, there are some matters that will come before you. You will have that, especially young lawyers, they will feel like they don't want to lose. You know, the more you lose there, the more your image will diminish. So it's when you become a lawyer, you will know the stress of being a lawyer. It doesn't just end. In fact, when you become a lawyer, another stress will come because the competition there is very big. And if you keep winning a matter, charge and bail are. So people will devalue you and all those things. But now, that's why a lawyer, no matter what, will not be prosecuted because he failed in winning his client's case, provided he didn't do it what? Negligently. So if you have maintained everything and at the end you still lose the matter, the court will still not say you have done anything wrong. But in this case, the man was under pressure to win the matter and he tried to go extra mile and then committed a crime. The question was, can he rely on legal practitioner immunity to stand against, you know, such an imposition? Because assuming now you commit a crime as a lawyer and you are exonerated, can you just be free to do whatever you like since you are doing it within the court process, or you are doing whatever you like, not outside the court? Can you still be convicted even though legal practitioner have immunity? So the immunity, the ruling of the court in this case is that immunity will only save you, provided that whatever you are doing is within the what? Bounds of the law. Anything contrary within the bounds of the law, you as a lawyer, you are going contrary to it, or you are going in for it. So what, like I said now, in this case, we have known that if a lawyer, within this rule 15, if a lawyer goes contrary to anything within the bounds of the law, he will not be exempted simply because he's a lawyer or simply because he's doing it in the interest of his client. Just like this thing also has something to do with the other case I mentioned, Linwood and what? Andrew, which still has to do with adducing fabricated evidence before the court. And the court held him liable for it, not simply because he represented a client, but simply because he failed to do whatever he was doing within the bounds of the law. Are we together? Then there is another case known as Labode against Godfrey Otubu. Labode against Otubu. Labode. Florence Labode against Otubu. Against Otubu. If you are going to court, make sure you have good name. Don't stress us. Before you go to court, if your name had wrong, man, just day your day. But sometimes, if you will see something, don't worry, it's on that level, man. You will be cramming cases, even the name self. The name is another thing to write down before you can go to exam. Which of rules of professional conduct talks about perpetuating interest? I think we should be doing this in because exam. Rule. A lot of people should by now call us Kagana as this one have one quote 17. So let's read rule 17. At the end, we'll be mentioning anyone we mention will know where it falls under, one by one. Lawyers shall not acquire a cooperative interest in the course of action or subject matter of litigation Thank you. This one is talking about that ebe many lawyer in issue because we are too greedy. You know, as a solicitor work of, you know, if you are called to bar, you will be called to bar as barrister and what? Solicitor of Federal Republic of Nigeria. Solicitor ordinarily in the English world is different from a lawyer, but in Nigeria now we combine. So here you are not only a barrister but a solicitor. Ordinarily, barristers are the main litigants. They are those who go to the court. Then the solicitor is more of, you know, property interest, selling property, agent, business related. They are just basically everything that has to do with company, you know, all those things that has to do with money. That is the work of a solicitor. But Nigeria will merge it up. You are everything. So in this case now, in this case of Labode and Otubu, that is what is boiling down to this what? The rule of what? Rule 17, interest. What happened in that case is that, so what happened in that case is that the client attempted, or the lawyer attempted to do away with the property of the person he was handling case for. Yes, his client. He attempted to pledge the property away. So in the course of the decision of the court then, the question was whether a person, a client, if you pledge as a lawyer, if you pledge a client property, whether the client can still retain it, and to what extent does a lawyer have over his client property as is concerned this rule 17. Remember, all these cases are specifically chosen for you to pass this thing. Are you getting me? So not that if you go to most of these cases cited here, you will be confused because there are major issues dealt there. Are you people getting me? So in a single case like this, you can actually see a lot of issues. That's why as a lawyer now, we are being trained to raise issues. You will see a problem question that has about 4 or 5 issues. In real court cases, you can still have issues, so many matters, the one that serves us on thoughts, even contracts, and so many more. But at the end, the court will make the ruling as it concerns each subject. Now, in this case, a lot of issue was dealt there, but this Labode and Otubu has to do with proprietary interest of a client. So whatever you are doing, you have no right by any means as a lawyer to pledge your property, the property of your client. And if that happens, the client is still entitled to regain it. Are you people following? So I'm saying this now, assuming a problem question comes and it has to do with a lawyer pledging the property, you now have the rule there, which is what? Rule what? And you also have the case to support it, right? So you can simply say, you must not necessarily mention the fact. You can simply say that it has been stated in the case of Labode and in the case of Otubu that a lawyer has no right to pledge interest, the property of his client. And even when he does so, the client is entitled to what? Recovery. Are we following? So that is how these rules apply. You pick this one here, you put it where it applies. Then you pick another one, you put it where it applies. You know, in Rule 19, in Rule 19 specifically has to do with information. So whatever that will go to Rule 19 has to be information. Then Rule 14, 15, and other rules, 17, can easily come. Because whatever goes with respect to proprietary interest of a client must go within the what? A lawyer's right to dealing anything inconsistent with it. Are we following? Rule 14 talks about being consistent with the interest of your client, still subject to the rule of law, right? Then when you talk about Rule 17, pledging your client property, is it still consistent with your interest of your client? It's not. So you see how the thing connects. So anything that can feature the other way can feature the other way. Then another case is case of Isho and Eno. In Yoruba, the S is pronounced as Isho. So, but how you spell it is ISO and Eno. But if you pronounce it, it's not be Isho but Esho. Isho and Eno. Don't worry, when I state the fact, I would like you people to mention the rule. People are grown up at this age in this thing. So, what in this case now, there was a matter before the court. Then after the matter ended, a lawyer went behind and waited for the fellow clients. So that everything is not by court. So there are some matters are not by about my lord. There are some they can, take care of ordinary. So the matter ended and then lawyer stepped down backward to visit the man. And if people saw this clip, they say, objection, kill you. Objection, kill your father. Now you go to TikTok, you saw something see like whereby the lawyer can be frustrated and start even bashing. So the lawyer, after deciding the scene, said that this matter will not end here. Then he went behind and approached the counsel and said, counsel, what did you even say there? So let's even reason ourselves there. So the gist of the matter is that a lawyer went outside the court to oppress the fellow lawyers. That is to challenge him. I think that is how the fact, that is what necessary for us to know about it. So I'm then asking you, looking at various rules, where do you think this can fall under? Rule 15, thank you. 26, that is another one. Somebody should read rule 26 for us. Somebody should open 26, somebody should open 50. Sorry, 15, my dear. So you owe yourself and your fellow lawyer a duty. That's why lawyers are brothers, not just in legal profession. Like everything that concerns you. That's why we address ourselves as learned colleagues. So if you go to court, it's not the way we see it here. The client may be enemies, but once the lawyers are done, they will shake hands. Because I can't carry your load. Now your load. Now you pay my school fees. I am there to catch my out and go. I'll just represent you, whatever, you will pay me. So there is no need for you to attach emotion. If I don't win this, I will die. If I objection, kill you there. You see, that's why what I like legal profession is that the more you grow, the more your emotional level will reduce. You know, in year one, we used to do, like, I will not be a lawyer, I don't want to go to hell. But now, guy, now they say the truth. If I tell my mother, they will be like, they are corrupt you now. But now, I learned that lawyers, now they say the truth. Because you just assume. Most of the thing people do is assumption. Yes, he killed somebody. That is reason for killing somebody, of course. Did you provoke me? To provoke me, I may be acting on impulses. I'm not liable because you provoke me. I killed somebody. Do you know whether I'm in mental good state? People are saying the law. Please, what I'm just trying to say is that there are some justification for whatever. We don't live on assumption. We don't live on morality and law are interconnected, yes, but there are two different things. So if you attach your emotion so much to your client case that it goes as seeing your fellow counsel as enemy, you are going against the rules of professional conduct. If a problem question arises and it presents in such a way that lawyer is showing any kind of animosity, just know that Rule 26 is at stake, right? And the case of what is at stake? So that is what another thing you have heard of Fawehinmi and state. It's very important also. Admonishment made in that case of Fawehinmi and state was that the counsel can be found contempt or can be liable for contempt if he attempts to, treat his fellow counsel without due respect, and also that of the court. So as a lawyer, by virtue of that Rule 26, you are mandated to be reasonable in your course of action, not just to do everything. That's why I say detaching emotion in legal field is very necessary. Because even if in your hall now, if you are too sensitive to emotion, you can answer your question wrongly. You just hear redeem, it's free, is not a pastor? So you just know that law is different from emotion, but they are related. Then there is another case. In case of R and Jordan. This one is just English case. You can pick this word if you like. R and Jordan. A lawyer, can you listen? Then can somebody, there is a section that talks about how a lawyer should treat the court. Section 26 is on lawyers, follow lawyer, right? Which one talks about a lawyer to the court? 31. Can somebody read it? The lawyer shall always treat the court with respect, dignity, and honor. If the lawyer has the proper ground for complaint against the judicial officer, he shall make his complaint with the appropriate authority. 3. A lawyer who fails to comply with any undertaking given by him, either personally or on behalf of his client to the court, is prima facie guilty of professional misconduct. Thank you. Prima facie guilty of what? What is prima facie? Thank you. At the face of it. On the face of it. Once you have done it, that's what I told you about contempt of court. It's very heavy. No need of trying to. It's the only law that authorizes or breaches right to fair hearing. In law, whatever you do, you will be entitled. They will hear from you. But once you are found guilty of contempt of court, no automatic. There is nothing like let me hear from you. Prima facie, that's what that rule say. Yeah? No fear, prima facie, duty of, especially if it commits it in the face of the court. Mind you, if it is before the court, maybe this case I'm going to tell you now, Aaron Jordan, is the one that happened before the court. A judge was giving a judgment. Then a lawyer made a very sarcastic comment and said that can be unjust. In fact, let me give you the exact word. So you can quote it actually, assuming the lawyer said, this is the most unjust remark. A judge was making a pronouncement. Then the lawyer interrupted and said, this is the most unjust remark. Can you imagine the weight of that? Like a court. You know, you have been in court, but you see how lawyers respect judges because they have much power. Take after God and them when the court is in session, after God and them. So you don't go there, say, even to press phone or to do anyhow. Then the lawyer, imagine the lawyer was back and he said, this is the most unjust remark. Maybe he was saying something, that didn't favor him. He said, this is the most unjust remark. And then they fired him for contempt. Yes, he disrespected the court. And in this case, it's a prima facie. Like, before the court, on the face of it, everything was clear. So what is the need of fair hearing again? The rest speak for instance. Let's see locutor. So you see now, when you are talking about that lawyer's duty to the court, this case is a very important one. I know all lecturers know this case. It's very popular because it's an English case. So it's very popular. What this thing is saying is that no matter whatever happened, yes, my Lord is the answer. If you have done well and they fail to recognize your destiny, yes, my Lord remains the answer. Then there is also there is another case, Maforis against Anye Bunam. See the same case, the court also admonishes on this issue of disrespecting the council and also disrespecting the court. I say Maforis against Anye Bunam. The authority in that case suggests is that a council owns a duty of respect to his fellow counsel and also to your fellow lawyer, the court. So that's why even as now, you should start from now. Your seniors, your colleagues, everybody. In law, you are best to disagree. You're always free to disagree, but you do it with all due what? Respect. That's why whatever you are written, say with all due respect. In fact, there are some judgments I will be writing, I will say, I disagree, but I will say with all due respect. Because if you disagree, you are free to disagree, but whatever you say, the law remains the law. Then, is there any other rule that you are finding difficult to understand? This time around, and I will advise you at this point, in all you are doing, make sure you write something in the hall. Make sure you write something in the hall. If you have plan B, plan C, even plan Z, make sure you write something in the hall. There are some places or there are some things the money cannot buy. The money cannot buy filling a vacant paper. And Lord Dennis said that you cannot put something on nothing and expect it to stand. So no lecturer will give you A on top of vacant seat. It's impossible. So in all you do, make sure you write, even if name area here, they will hear ban. So that it will not be that you left your distance vacant. In fact, just make sure you write down something. Use your understanding. If authority no gree come out, use explanation. Be talking. So that it will not be problem question comes. I like see apply. What is I like? Issue, rule, application, and conclusion, right? Remember, here now we have already existing rule. This one is not like you going into voyage of discovery to search for rule, right? This one is already there. The only one we end up doing now, we are searching for cases. Let it not be that we answer through only rules. So we already know that this one is the rule. Now, if the question comes, issue, then if the question come open-ended question means after saying everything, they say, using relevant authority, advise the necessary parties, open-ended. After saying everything, they say, examine issues. After saying everything, they can just say, advise the party on the proprietary, advise the party on the validity of the action or otherwise. Whenever you hear, there is one word they use prepare something, I've forgotten that English, but it means on the validity. Can you remember that word? On the propriety, propriety. Yeah, that word will come. It's better you learn that word. You'll be seeing it in legal question on the property or otherwise. Property here doesn't have to do with property, like proper. You got that? Proper, property. That is, I think, it's adjective. Like whether the thing is proper, then otherwise is whether it's not. Please learn that word. It can throw you off balance. That word is, you'll be seeing it from now, from year 2 now. You'll be seeing it.